Misrepresentation. Along with me is my business partner, Stephen Brown. Stephen, one question that I have is that if people have committed any misrepresentation, fraud, or sometimes even if they have not committed, the USCIS or probably the State Department or CBP has determined that they have committed fraud, what are the options available for them?
Yeah, so I mean, the problem is for most of these fraud findings, almost all of them, it's going to come with a permanent bar from the United States. So there are waiver options available. We're going to focus today's conversation on the non-immigrant visa options, but there is a separate process and procedure available if you are applying for a green card that you can waive this issue as well.
So if somebody is hit with misrepresentation or fraud or willful misrepresentation, what is the process that is involved in them for getting the visa stamping and coming back into the United States?
Yeah, so you would, still schedule your visa appointment like normal, right? On the SEAC website, complete your DS-160, go in for the interview. When you go for the interview, or, you can maybe wait to decide later, you would present a 212D3 waiver, also called a Harranka waiver, H-R-A-N-K-A, waiver application to the consular officer. Now, there isn't a form. It's just going to be a brief that you would take to the officer.
So, for example, if I'm applying for a H-1B and there is a fraud or misrepresentation, the OPT, STEM extension, maybe I worked with the wrong company, represented myself with the DSO in a wrong way, and now I have hit with the misrepresentation. How do you apply for the waiver when I got the H-1B approval?
Yeah, so, there isn't a formal, like USCIS, you've got to file a petition, send it to USCIS. For these non-immigrant waivers, there's not a petition. What you would do is you would go to the consular officer and take a packet going through the Harranka factors about why you qualify for the waiver under the Harranka factors, why you qualify for the 212D3 waiver, and, the facts and the evidence that support it, and provide it to the consular officer.
So I just go to the consular officer, present it, and do I need to do anything on the DS-160 form or inform them that I'm coming for the waiver? How to fill the DS-160?
Yeah, so the DS-160, I think my big thing that I always recommend to people is to be honest, right, on the DS-160. You don't want to compound your fraud or misrepresentation with more fraud or misrepresentation. So when they ask about the admissibility questions on the DS-160, answer truthfully, yes. And you can answer, yes, I've been found to commit fraud or misrepresentation, but I'm going to apply for a waiver. You don't have to tell them that, because when you go for the interview, they're going to say, Rahul, you're not eligible. I have a waiver.
So one thing, Stephen, that I have a question here is that, what if I believe I have not committed fraud, but the USCIS has determined I have committed fraud, or the State Department is saying that I have committed fraud, and I don't think so I have committed fraud? How do I answer in the DS-160 form?
I think we've gone back and forth on this quite a bit in our office, because there's a lot of things that as attorneys we don't believe are actually fraud. Fraud is a high bar for immigration to have to prove. And there's a list of factors that they have to prove, not just fraud and just say the word. It still, I think, would be important to say yes on the DS-160. And in the waiver application, you can go ahead and brief, I don't think I should have been found inadmissible due to fraud because da-da-da-da-da, but in light of the findings, here's how I qualify under the Harranka factors.
So if there is a determination made by the USCIS or the CBP, or in case like in the State Department, that it's a willful misrepresentation or fraud, I should answer yes. That is a better strategy, and then go argue with them saying that, look, I have not committed fraud, here is the reasons, but if I were to commit, these are the exemptions, I should be, then they'll be requesting for the waiver.
Absolutely.
What are the factors that need to be, that the department looks into in granting the waiver?
Yeah, so I'll talk about the procedure a little bit from the consular side and the factors. So the consular officer that you do your interview with, they don't make the determination on the waiver. They'll basically give, what I colloquially call a endorsement. They'll say whether you're applying for the right waiver and say, yes, we'll accept it, and then provide it to the Admissibility Review Office in the U.S. The ARO is the one that does all these determinations. They look at 3 factors from a Board of Immigration Appeals case matter of a Harranka. They're going to look at the recency and the seriousness of the activity or the condition causing the admissibility, the reasons for the proposed travel to the U.S., and the positive and negative effects, if any, on the U.S. public interests.
So, Stephen, you said that in the DS-160, we have to mention very clearly about the fraud and misrepresentation, and then we have to present ourselves in there, make an argument, maybe I should not be coming under willful misrepresentation or fraud, or if so, I come under it, please grant an exemption, we present the brief and all those things. And you said that the consular officer will take that one and send it to the ARO office,
Yes.
and it will be determined in Washington, D.C., I guess.
Correct.
Based on that. But so I just have to, and there is no formal page, no filing fees.
No, you're just going to present the brief and the evidence to the consular officer. Now, I do want to note for Canadian nationals, because Canadian nationals are visa exempt, there is a form that they're going to have to submit at CBP, but otherwise the procedure is the same. They just submit the brief and the evidence.
So there's no way we can email it to the consulate. It has to be physically presented at the
Correct.
time of the brief has to be presented.
Absolutely. So
And-
when I go for my interview, I've been determined to have committed immigration fraud. Rahul's going to prepare my packet for me, and I'm going to go to the consular and hand them my complete packet.
And how much time normally it takes from the consulate to go to the ARO office in Washington, D.C., and get to granted the waiver?
So the ARO shoots for 150 days, but that's not happening. It can take a year or more, and I think that's a factor that needs to be considered. At least how long you're going to wait for these waivers, because this waiver, Rahul, this 212D3, this Harranka waiver, is for most non-immigrant violations that would cause you inadmissibility. So unlawful presence, where you have the 5-year bar, that would be the same waiver. So if you're at year 4, maybe you wait.
Yeah, okay. It's year 4. Why go with all the legal expenditure? It's going to take 1 year. Why do that?
But for fraud, where it's a permanent bar,
Forever. It's
Yeah.
probably.
this is
For 5-year bars, maybe we need to look into, or 3-year bar, or 10-year bar.
Yeah.
We need to look into whether it's not worth to go through the process or wait, because it's going to take more than 1 year anyway to get the
right.
process.
But for fraud, where it's a permanent bar, unfortunately, it's going to be file and wait, and you can't litigate a delay because it's such a discretionary benefit.
And once the gentleman files the waiver, though, and you said it's going to take 1 year approximately plus, you never know the timings of those things, and they deny the waiver, though, what are the options? Can we sue them?
No, I mean, you can't sue. So because they have complete discretion, you can't sue. There are potentially some options to appeal, but it's going to go back to the BIA.
Is there anything else people need to know about the waivers?
No, I mean, waivers, especially these non-immigrant waivers, can be tricky, not only in applying for them, but maintaining them. So they're only good for 5 years. And for Indian nationals, they're going to be on their non-immigrant visa for the most part longer than 5 years. So you may have to renew the waiver. The waiver is only going to be valid for the reasons and for the visa categories listed on the approval. And this waiver, so if I get a waiver for the fraud for my H1 or my H4, that doesn't mean I'm waived on the adjustment of status side or the green card side. You would need a separate waiver, completely different set of circumstances, factors, qualifications. But when I go to apply for that, you're going to have to do a different waiver at the green card side.
So let's say I've been hit with the fraud and misrepresentation. Let's say that is on H1B because I paid the money to the consulting company to get a H1B. Let's say I did that, and then and I'm now applying for the H4. Okay, if I'm applying for the H4, though, you mean to say if I get the waiver, I can come here on H4, but I cannot transfer it to H1B.
There may be mechanisms to do that where they're going to relook at your qualifications when
We
you
have to
apply.
go back to the consulate and
But it
apply.
might not have to go through the waiver, but they could require you.
Okay, so it's not that easy to change from H4 to H1 again after coming to the United States.
Yeah, it may be things where there's different considerations, more so than a typical change of status. So it's worth talking, I think, to an attorney if you're looking at that.
And typically, if you were to apply prepare for a waiver application? How long does it take for you to prepare and give it to the client?
And
you want to get involved in the DS-160 filling too, right?
Yeah, I think so. I mean, from my end, it's going to be something that it's not going to be overnight. That's for sure. It is going to be something that I'm going to tell you, hey, it's going to take a little bit of time because I want it to be a partnership between me and a client. You know your facts. What are you coming to the U.S. for? What are your sympathetic facts more than I do? I can make all the great arguments, but I do want to make sure we have some phone calls, talk this out, make sure you guys understand everything. But, we could get it done, have a good turnaround time and let you get applying for it and then let it sit with the AR now.
Anything else, Steven?
No, and, this is something, we are seeing more and more of, whether they're proper fraud findings or improper fraud filings. And so this is something we're ready to provide if people need it.
And if you want to consult Stephen Brown, I have put a link there. You can go to the link, and his schedule is available online. You can make an appointment and speak with him. Before you speak with him, though, if you have any documents, we request you to upload the documents in the appointment portal. And especially if anybody has been deported or been sent back, we want to look into the sheets that you have been provided at the airport. Before you speak with Stephen, you need to have all those things available, though. Any documents that you can provide to him before you have an appointment, and that's there in the appointment portal you can fill. That's going to be much better for him to evaluate when you speak. Otherwise, you're going to waste your time and also waste his time, which is not in your best interest.
No, thank you. And hopefully, for some of you that are in bad situations, we can try to help you out.